The child support cases make you wonder why people need to get divorced in the first place. It pains to see people who once loved and cherished each other fight for custody and who gets child support when issues like this could be avoided in the first place.
If I say it again, I'm going to find you contempt. When any issue happens before, I'm going to have my deputies come get you.
Had false allegations and lies thrown my way. Behavioral, I think, is not in a child's best interest to have one parent to try to demean the credibility or the character of another parent.
Was there an agreement for this beforehand?
Absolutely not.
Well, Your Honor, my client reached out to the defendant a couple
Ms.
times.
Bills, I want to tell you, you don't talk unless I ask you to.
In this video, I want you to observe how divorce can also affect women who initiate it, but still demand excessive payments, as if they are owed something for being idle and entitled. So before we dive into the video, don't forget to like and subscribe. It really helps me connect with more amazing people like you. The father, Mr. Bills, moved to New York, making the current parenting schedule every other weekend. Miss Bills, the mother, claimed her wages were being withheld for child support, but the father stated he hasn't received any payments since August. The court will finalize child support only after the parenting time is settled, since the amount depends on the number of nights the child spends with each parent.
Present with the respective attorneys, that is, Miss Bills is represented by Mr. Murphy. Mr. Bills is represented by Ms. Bueno. This was the plaintiff father's request for parenting time, child support, and extracurricular support. Let's start out and do the easy one. It's clear that we're going to have to modify parenting time somehow because Mr. Murphy, your client, moved to New York, and we're obviously not going to do every other weekend or something like that.
That is correct, Your Honor. We'd like to modify, and I think both sides want to modify, yes.
Yeah. All right. And I don't know that you guys have reached an agreement on modifying, although I would ask that the two attorneys discuss the matter so that they can try and reach an agreement. I think the best thing to do is either to send it to mediation, or quite frankly, if the two of you want to set up a settlement conference with me, I'll give you a half hour or something in the real near future to try and work something out. I mean, there's only X number of days that she can get. It's summers and breaks and stuff like that.
Agreed, Your Honor. We're happy to talk to the opposing counsel on that. I think we can work something out.
All right, Ms. Bueno, it's your motion, but I mean, I'm not going to find anything here today. If we have to, I'll have an evidentiary hearing, which would be god awful for just for parenting time when we know
Right.
certain things about it.
I would just add that I did have a chance to speak with opposing counsel yesterday. We're close, but not close enough, just based on the lack of parenting time that the defendant has chosen to have up to this point. So, I mean, I think having a settlement conference with you to get your feedback on what we should do going forward is probably the best solution.
Well, I'll ask the two of you. That's fine. We'll try and get you in here in the next week or two or whatever for a quick settlement conference. What it would be then is I would ask the two attorneys to come into my office, and I'll give you my thoughts on it, and we'll see if we can't figure something out. All right.
That'd be fine, and I'll provide a updated proposal to Ms. Bueno also.
And that would be great. I want the two of you to provide proposals to each other before you get in here, so I know where we're at least if I have to work on some of that. My clerk will get in touch with both of your offices and try and set something up. Yeah, it's either got to be later next week or like 3 weeks down the road, because I'll be gone for a week. So we'll get you in as quick as we can. Although there isn't any quite frankly, real rush on it, because there isn't going to be parenting time in September and probably nothing really in October. We got to get something on the books before we get to Thanksgiving and that kind of stuff.
Right.
Very good.
We'll work with both of you and see if we can get you in here, okay?
All right.
All right. Child support. I'm going to hold off a little bit on child support because basically that's going to depend. Some of it depends on number of overnights, and we're going to figure that out at the settlement conferences, what the number of overnights are going to be. They're not going to be a huge amount, I'm sure, but there was a UCSO of 52124 that listed 52 overnights. Ms. Bueno, anything you want to say?
I would just ask that if the defendant has actually started her job in New York, that we be provided pay stubs for that.
Yes, I am employed.
She's employed at Target, as I understand, the same as she was employed at Target here.
Well, I mean, my client hasn't received any child support since the beginning of August. So that's why we're a little confused on why there's a big gap.
The whole reason for that was I took a leave of absence to make the move. So he will get that money all retro. They
So-
garnish my wages. It's taken out every paycheck.
Target takes it out,
Yes, sir. Yes.
you get it. You'll get what they take out and stuff like that, and any other enforcement you can do through the friend of the court, but basically, looks like there was a brief time period of, they were not taking it, but she's telling you that they are taking it out of her check, and you know as well as I do that there's a delay between taking it out and getting it.
Right, I would just ask for some pay stubs so we have accurate information.
And vice versa, please, regarding your client.
Yes.
Okay, you guys can exchange.
The father asked for reimbursement for tutoring and other extracurricular costs. The court denied this request as the divorce decree doesn't include provisions for these expenses. The judge emphasized that the father must cover these costs unless a new agreement is made.
Parties that put it in the judgment, then that's fine. But you're asking for something that is not in the judgment of divorce.
That's correct, Your Honor.
And I mean, if you can point it out to me in the judgment, that's fine. But other than that, these are extracurricular activities she's not required to.
And
No,
frankly, Your Honor, we believe that that's an exorbitant cost. That's a big one. He needs to get pre-approval, and he's trying to nickel and dime her on this entire matter for whatever reason.
Your Honor, he's not trying to nickel and dime her. He's trying to get the kids whatever they need. And I understand that it's not in the judgment of divorce. But I mean, that's part of the reason, part of our motion now is because he's had such a hard time trying to get any kind of assistance. And so he's asking, at least from this point forward to get assistance.
Well,
You know,
Mr.
Hold on, Mr. Murphy. You're asking to modify a judgment of divorce from 2016 or 2017 or something like that. And on a property type matter, and it's not modifiable for that. It's just not.
I'm not asking to modify it. I'm asking from this point forward.
That would be a modification because you're asking from this point forward. Okay?
That makes it a post-judgment matter, not a modification of judgment matter.
Okay, then what you can call it anything you want. I don't find that I'm in a position to modify that judgment to going forward, that it would be a part of a judgment that they're extracurriculars. I'm sorry, it's a bad deal for your client, and I'll tell you, he's doing a great job and she's not helping out very much, but it's not in there. And I'm not going to modify and now add something because that's what you're asking.
The court is focused on finding practical solutions that meet the child's needs. The judge encourages both parties to reach agreements through settlement conferences. No modifications will be made to the original divorce decree regarding extracurricular costs.
There is nothing in there that requires her to pay extracurricular type of activities or events.
Okay, I understand.
That's,
Thank you, Your Honor.
I'm sorry. Anything else, Ms. Bueno, you want to put on the record?
No, I don't have anything else.
All right, then, who's going to draft the judgment there, the order that says that is denied? I will, set a settlement conference as promptly as possible regarding, parenting time. Parties shall exchange in 14 days, financial information and pay stubs, basically. And, that will reserve, child support pending.
This court hearing involves a custody and visitation dispute. The father claimed the mother denied him visitation rights, which led to a contempt filing. The judge reviewed recommendations and reports from a previous hearing, though it was unclear how far along the review had gone, and watch how tensions rise.
If I say it again, I'm going to find you contempt. When any issue happens before, I'm going to have my deputies come get you. Is our civil contempt. We have 3 matters on the calendar this morning. I'm going to call the case. Let me know if you're here. And then for Ms. Habib, how much time, Ms. Bouvier, how much time are you requesting? Ms. Bouvier, I thought I saw, okay. I can't see you at this juncture and your video, and your sound is on mute.
10 minutes.
So let's put time in there.
Your Honor,
Oh. Okay, give me. All right, give me one moment. So the court had an opportunity to review those, and has a better, understanding of background. I can't remember exactly how far we got, in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. We have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of trial. Middle of the hearing now. So you have to have your video on. You turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter. Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments to date. Moving forward, according to Georgia Code Section 1512-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right. Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay, so first you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm going to have a hearing without you. Okay, so turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue would be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It will be you, London Bouvier. Okay, so I want to make sure you understand that. So is that clear to you?
The mother representing the descendant has not waived any legal rights. She requested a jury trial and filed an amended notice for recusal, citing relevant Georgia code sections. The judge denied the motion for recusal due to insufficient evidence and reminded that custody cases cannot have a jury trial.
This order been followed? Is it being?
No, Your Honor,
Yeah.
that's why we're here.
It's not being followed.
No.
No, right. We filed a contempt on this order on May 7th.
Really? I don't know what's happening. Okay. I assume I had thought that this matter was coming back on the calendar because I continued it from the last matter, but now I understand. Okay, so there is also the contempt on the interim order.
That's
right.
correct, Your Honor.
Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
That's
It is
correct.
not.
That's the issue. It being followed at all, like no visitation, or just being
No visitation at all, Judge.
All right, Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay? You turn it off again, I will find you in contempt of court. All right? So you will spend 10 days in the Cobb County Jail. You turn the video off again. Okay? Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt, and I will pick you up. And your child will then go to Mr. Habib. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court. 10 days in the Cobb County Jail. Child will be presented to Mr. Habib. These matters will be continued thereafter.
The judge found the mother in contempt of court and sentenced her to 10 days in jail. The child was ordered to be returned to the father, and an order was prepared to transfer custody to him. In this video, we'll be covering a court hearing where the father, Mr. Bruce, is seeking full legal custody of his son, Caleb, from his ex-partner, Ms. Gallimore. Let's dive into the arguments presented. Mr. Bruce wants to move and argues that Ms. Gallimore's home environment is negative for Caleb. He believes staying with him is in Caleb's best interest. Mr. Bruce claims that Caleb wants more freedom in deciding how and when he sees his mother. He accuses Ms. Gallimore and her family of making false accusations against him, which makes him concerned for Caleb's safety.
Had false allegations and lies thrown my way. Behavioral, I think, is not in a child's best interest to have one parent to try to demean the credibility or the character of another parent.
And sir, you filed a motion to change custody, is that correct?
Yes, sir.
Gallimore, are you in agreement or opposed to that request?
I am opposed to that request.
Okay. So, Mr. Bruce, in looking at your motion, it just seems like what you really want to do is move, is that correct?
That is the plan, Your Honor.
All right, so there is a different motion that is filed when somebody wants to change a legal residence. You filed a motion to change custody. There's different rules and procedures for both motions. For a motion to change custody, you have to show proper cause or change of circumstances. I don't think your desire to move would be a proper cause or a change of circumstances to change legal custody, but there is a motion to change legal residence that you can file.
Well, I did include in the with the order to change custody. There is other reasons, Your Honor. You know, Caleb and James has been with their dad for 8 years. The plaintiff and her family has restricted what I would call normalcy with everything I already turned in and stated with the court. I apologize for missing the last appointment there to oppose the additional parenting time. There's just a lot of reason to, after considering Caleb's age and the years that he's been with his father, you know, going on a decade, and with the plaintiff's history and the recent behavioral things that I've submitted to the court, it would be in Caleb's best interest, I believe, as his father, to have full legal custody of Caleb. He's 15. You know, has stated that for the parenting time that he didn't understand why he couldn't make the decision to see his mother when he wanted to. I happen to agree. I know the court has its parameters for that. You know, I've been threatened. I've had false allegations and lies thrown my way. Behavioral, I think, is not in a child's best interest to have one parent to try to demean the credibility or the character of another parent in the nature that the plaintiff and her family has done, Your Honor. And like I said, I've been a single parent of both boys for over 8 years. And it's up to me to protect them, to shield them, to guide them, to keep them away from bad characters, bad nature of circumstances. And I believe that the plaintiff poses that with their growth and prosperity ultimately. I don't know if I have to submit the same information. I did the first two parenting time reviews and requests by the plaintiff that ultimately decided not to change those parenting time. I understand the parenting time was changed to the request of the plaintiff due to me not making that appointment in that morning. But I can't ignore, this coming from me, Your Honor. If you look at everything that's been said by me and the plaintiff, this is not a spiteful move. This is, I'm here to do what's best for the children, like I have improving myself for the last 8 years. I think it's detrimental to so many aspects in his life if he's being made to see a parent that's been absent with the circumstances that I've described to the court. In the past 6 years I've been back here in Gaylord. It's evident, it's all there. I also, I planned on making that appointment for the last parenting request due to I get a copy of what the plaintiff and her family, her sister Danielle, I can't remember her last name at the moment, submitted papers to the court making accusations that are completely false. Also in the hearing that last with you, you gave me the chance to ask questions to the plaintiff and any of her witnesses. And from what I see, clear to see that the plaintiff and her sister come over and tried to say they would make up a story that I did something to have me falsely persecuted. That's a big conflict of interest to me or anyone that I know that is a parent or just a person that has to deal with that. You do not make accusations that are untrue to try to imprison or to demean them or inhibit their way of life on false accusations. That to me is a very bad character flaw. And if Caleb, our son, were to know a friend that had family or immediate parents that were, around him that had that nature, that quality of behavior, I would feel it upon myself to keep him away from that kind of person that could do that, to ultimately try to persecute or have somebody persecuted based on false allegations and threats. And that's exactly what's done. I can go in great more detail. There's a lot more to go into. I didn't want to relive this and bring up the history of her questionable parenting habits and scenarios that's already has happened and has been documented and has what I'm aware of. I just think it's in Caleb and James and honestly, Your Honor, Caitlin's best interest to have someone moderate the way that the plaintiff is parenting and the risk that it imposes to do the threats and the behavior that I've seen arise to the surface again, which I was hoping would end after so many years of evolving and maturing. So to me, it's very detrimental. I'm here to protect Caleb and his future and his emotional standings. In the 8.5 years that I've been a solo parent.
All right, Mr. Bruce, I'm going to cut you off because you've kind of rambled a little bit beyond what the question was at hand. So it sounds like now you are also requesting that parenting time be changed. Is that correct?
Yeah, I would have never agreed to the.
All right, well, hold on. All right, you can just, I just need the word yes or no there. So you're
Yeah,
asking to
sure.
change parenting
Yeah.
time as well as to change custody. I'm going to indicate, when we look at changing parenting time or custody, we look at what the last court order was. What is the change of circumstances or proper cause then to change those? There was just an order entered by Judge Mertz in March, not even a month old at this point. So I don't think there's certainly any change of circumstances alleged since that order went into place. So as to your motion to change custody, I'm going to deny that and indicate there is no proper cause or change of circumstances. Again, there is a specific form you can file if what you want to do is move. That is a motion to change the legal residence. I'm sure a friend of the court has that sample form present here at the office. So if that's what you're looking to do, a parent can certainly move and the parties can still have joint legal custody also, so that legal custody does not have to be severed just because a party is moving. So as to your motion regarding custody and or a parenting time change, I'm going to deny that for lack of proper cause or change of circumstances. And then if you want to pursue something different with a move, you've certainly got that legal right to file the motion that is directly on point with a request to move. Do you have any questions, sir?
I sure do, Your Honor. I don't understand the circumstances that has changed that warranted the first or the last motion for the parenting time to be changed, other than I was absent.
In custody cases, there must be a significant change in the child's life or environment to justify altering custody. Mr. Bruce is arguing that these changes exist. Ultimately, the court's decision will be based on what is deemed to be in Caleb's best interest, a key consideration in custody cases. Mr. Bruce expressed confusion about recent changes in parenting time and requested clarification on the new schedule. It's clear Mr. Bruce would benefit from legal representation to help him navigate the complexities of custody modifications and ensure his rights are protected.